Days of high drama have come to an end at the Supreme Court, but the suspense will continue until the High Court rules. The justices heard more than 6 hours of arguments about the constitutionality of the health care law known as the Affordable Care Act. Fox's Craig Boswell takes a look at what they had before them on the final day of arguments.
Opponents of the health care law made their voices heard outside the Supreme Court from day one. After 3 days of arguments, the attorney representing the 26 states opposing the Affordable Care Act also spoke outside.
Even if the court did nothing more than strike down the individual mandate, it would be a very significant victory.
The question before the High Court today is what to do with the remainder of the law if the mandate is, in fact, tossed out.
The more conservative approach would be salvage rather than throwing out everything.
Throwing everything out is what opponents want. The government says striking down the entire law is not necessary, and some portions of it are already in place.
There should be no occasion for the court in this case to consider issues of severability because, as we argue, the minimum coverage provision is fully consistent with Article 1 of the Constitution.
Another central issue is the ability to keep health care costs down without the mandate, which is intended to fund the law and provide coverage to about 30 million uninsured Americans.
Once you cut the guts out of it, who knows?
The final hour of afternoon arguments focused on Medicaid expansion and whether the federal government can put more Medicaid demands on states.
Why shouldn't we be concerned about the extent of authority that the government is exercising?
It's now up to the court to decide.
Starting on Friday, they will meet at 10 o'clock in the morning and we'll vote. And there'll be votes on all the different issues that they've had oral arguments on.
A ruling could come at any time, but it's not expected until the end of the Supreme Court's term in June. In Washington, Craig Boswell, Fox News.
Here now to help us understand what the justices have to consider is attorney Proloy of McGuigan. Thanks, Proloy, for being here.
Well, thanks for having me.
It's a complicated issue, clearly, but much is being made, first of all, of the president's strong language that he used regarding the Supreme Court. I had an attorney here on the day that it happened, and he was stunned by it. And I'm wondering, I mean, were you similarly surprised at the aggression that he had?
No, I mean, I think that the comment itself really wasn't that significant. Obviously, the president believes that it would be unprecedented to declare the statute unconstitutional. Anyone that likes a statute and sees it declared unconstitutional would think it would be unprecedented. What I was surprised by was the soundbite being that exaggerated. It took the form of the Fifth Circuit Court of Appeals requiring the administration to file a letter explaining his position on Marbury versus Madison and the power of judicial review. I thought that was an interesting aspect.
And that really clarified that that he recognized that they did have the authority, or?
Right, and I don't think there's any doubt from the government's position that the Supreme Court has the authority under its doctrine of judicial review to declare statutes unconstitutional. The question here, and really the heart and soul of the Affordable Care Act, is the individual mandate, and whether or not the Supreme Court should declare the individual mandate to be unconstitutional.
And so what will they become? What are the arguments being made about that? And the individual mandate is such that it will require everyone to carry health insurance.
Yeah, that's correct. I mean, what Congress was trying to do when they adopted the ACA was they were trying to deal with a problem with 40 million Americans who don't have insurance because pre-existing conditions, they can't qualify, the cost of premiums is too high. So Congress said, okay, we're going to eliminate this discrimination against individuals with pre-existing conditions. But in order to pay for that, we're going to require everyone that's healthy, that doesn't necessarily have strong health care demands, to get insurance. That's the way they can cover it with the premiums in order to ensure that we can have this adequate coverage.
Okay.
The problem that comes up from a constitutional standpoint, and this is really the key provision that's subject to debate, is whether Congress has the authority under the Commerce Clause of the federal Constitution to require individuals to buy a product. The administration is arguing, well, this is health care is something that affects all the states. It crosses state lines. So, of course, we can pass a statute requiring somebody to get this coverage because the cost is going to be placed on somebody else. Paul Clement and the 26 states are arguing, well, wait a second. Your powers of the federal government are limited by the federal Constitution, and that power does not allow you to force an individual to go buy a product.
But I have heard this argument, and it kind of made sense to me. But I mean, we are required to buy. we're required to buy other types of insurance, car insurance, homeowners insurance.
And that's a great example. And actually, Massachusetts actually has the requirement that you go buy health care. This individual mandate worked in Massachusetts. And the answer is that there's a lot of things the states can do under the 10th Amendment, under their general police power, that the federal government can't do. So that's what this case is really about. Not can we make someone go buy this product, but can the federal government make someone buy the product? So the federal government's limited by the federal Constitution. It's allowed to, 18 different powers are set up in Article 1st, Section 8. They include like the right to coin money, establish a bank, a post office, you know, things are of a national nature, and one of them is regulating commerce amongst the states. What the states are saying, wait a second, you know, we're the ones that require a person to go out and buy car insurance before they drive a car. We're the ones that should be requiring an individual to go buy health care.
I see.
And so it's really why the case is so important. It's really going to be a major decision on what the role of the states are and what the role of the federal government is.
So we have less than 2 minutes left, but so what are the options? I mean, how could they rule?
There's a few things they can do. One is the 26 states are arguing is that declare the whole thing unconstitutional if you find the mandate to be unconstitutional. The government is arguing the whole thing should be viewed as constitutional because they're acting pursuant to their powers to regulate commerce, and it crosses state lines. If the third day of argument was really focused on what to do if they find that mandate to be unconstitutional, and can they sever it. What the 11th Circuit did is actually severed this provision with respect to the individual mandate, but left in place the anti-discrimination part. Well, the government said, well, that doesn't do us any good because it's not going to work. We need everyone to participate in it. But the government's also saying, but there's a lot of other portions of the 2,700-page bill that can stay in place. So just strike down those portions of it, allow the rest of it to survive. The states are arguing, look, if it's unconstitutional, this was the key provision of this statute, strike the whole thing down and let Congress get another shot at it.
Interesting, interesting. And so it's a decision that'll be made, I guess they're saying in June?
Yeah, traditionally the Supreme Court has all decisions released by the end of June. That's just out of tradition. This year, June 30th is on a Saturday, so the 29th, everyone's expecting a decision to be released by.
Interesting. Great. I really thank you for coming here and explaining it so well, Proloy. Thanks a lot for being here. Gas prices, presidential nominees, and the death penalty. We're going to tell you the latest on all of them coming up. Speculation is gas prices could top $5 a gallon in some places this summer, and some in Washington, including Connecticut's U.S. Senator Richard Blumenthal, believe speculation is part of the problem. Fox Connecticut's John Charlton takes a look.
A U.S. Senator pumping his own gas. Richard Blumenthal suggests that some of his congressional colleagues should try it.
These are better prices than I'm usually getting.
To get back in touch with the average American instead of appeasing the big oil lobby.
They have a very strong hold on certain members of Congress and senators, and we need to break that hold.
And those who refuse, Senator Blumenthal warns, can be held accountable by Americans who vote at election time.
The profits of the 5 major oil companies last year were $137 billion, and yet they are receiving every year billions of dollars in tax breaks and giveaways.
Senator Blumenthal wants that to end, as well as an end to high-octane speculation on Wall Street, which drives up prices. He plans to push the Commodities, Futures, and Trading Commission and the Justice Department for more control. Michael Fox, executive director of the Gasoline Automotive Service Dealers of America, claims speculators make up 87% of all futures contracts in the industry.
Their fiduciary responsibility to their investors is to buy low and sell high. We've got to get them out of the market.
Another measure Blumenthal supports is stopping the export of oil made in America from public land.
If it is drilled in America, it should stay in America.
American consumers we spoke with while filling up say they'd vote for that.
We're worrying about helping other countries. We need to help ourselves before we can help them.
You're talking about major reform, not just in oil, but just the way Washington is.
Mitt Romney made a play for female voters at his campaign stop in Hartford this past week. The Republican presidential frontrunner stopped at a small business on his first full day as the presumptive nominee, now that Rick Santorum has exited the race. Mitt Romney bounded into Hartford, taking up a spot flanked by risers of women, and like a laser focused on the difference he sees between he and President Obama, saying overregulation hurts business owners like the woman who owns Alpha Graphics, the printing company that hosted his event.
In his 3.5 years, 92.3% of the people who've lost jobs have been women. His failures have hurt women. If I'm the next president of the United States, I will go to work to get American women good jobs, rising incomes, and growing businesses.
Romney's stop with a focus on women was by design. He is seriously lagging in the polls in female support, and his campaign was getting some criticism just this morning when during a press call his team was asked if he supports the Lilly Ledbetter Fair Pay Act, and they responded, "We'll get back to you on that." They have since sent out a statement saying, of course Mitt Romney supports pay equity for women. Romney spent about half an hour before his public event with 6 local women who own businesses. He says their message is very clear to him.
They don't feel the government is their ally. Each of them said, in effect, it would be nice if government got out of the way.
His plan worked on at least one woman today. Karen Brinker owns the business that hosted Romney. Unaffiliated, she says the campaign called her and never asked her about her politics when they booked the stop here. But now, after meeting Romney, she says he listened to her and then she heard him.
I think the speech he gave was right on. Get government out of the way so I can run my business and hire people and carry on. And I think everything he said is, I agree, is the change we need.
In Hartford, Lori Perez, Fox Connecticut News. The long-contested bill repealing the death penalty in our state is on its way to the governor's desk. This after a vote of approval from the State House of Representatives. Fox Connecticut's Anthony DiLorenzo reports.
Bill as amended is passed. Capital punishment in Connecticut continues its slow death, years in the making. The governor's signature, all that stands in the way of a final repeal of the ancient law.
I'm glad that we had the vote that we had. I think it was a respectful debate, and I'm happy to see that Connecticut has moved forward in abolishing the death penalty.
After 10 hours of debate on the House floor, the General Assembly voted to make Connecticut the 17th in the nation to abolish the death penalty in favor of a life sentence without parole.
The body believes that incarceration without any possibility of release is a fair, impartial settlement for capital punishment.
After years of failed attempts of a repeal, it was a contentious debate that came with Republican resistance.
Many people are making their decision on whether or not to vote for this because they are trusting that even if it passes, those 11 animals on death row will die.
Lawmakers were able to finally seal the bill's fate by allowing the 11 men currently on death row to stay there, a provision some call political since only one man has been executed in 51 years.
The constitutionality of having a bifurcated system will never be held up. There isn't a lawyer, defense, or prosecutor that believes for one moment this will be held up.
Still, lawmakers on both sides of the aisle point out more needs to be done to overhaul the state's criminal justice system.
Don't forget, if you missed something here on The Real Story, you can now watch it online by going to ctnow.com. You can also catch us on YouTube. Thanks for watching this week's edition of The Real Story. We'll see you here again next week.